Hi, and welcome back to the Freedom Law Group Law Library. In this video, we'll be discussing communication from the IRS, what it means, when to respond, and how to handle it confidently and lawfully. There are some individuals within the broader freedom movement who teach that once you've revoked your election to be treated as a taxpayer, you can safely ignore any and all future correspondence from the IRS, because, they claim, the IRS no longer has jurisdiction over non-taxpayers. While that claim is partially true, it's dangerously incomplete. And following that kind of advice can lead to serious legal trouble. Here's the truth: once you complete a properly executed revocation of election and send it to the right federal agencies, the IRS does, in fact, lose jurisdiction over you for the tax year in which the revocation was filed, and all future years moving forward. But that doesn't eliminate any liability for past tax years, especially if you filed a 1040 return in those years. If the IRS contacts you regarding a year that predates your revocation of election, you must respond. The revocation is not retroactive, and ignoring IRS letters related to past filings can result in default judgments, penalties, or enforcement actions. Even for future years, it's important to understand this. Nearly every IRS letter begins with the phrase, "Dear Taxpayer." If you don't respond or rebut that assumption, the law views your silence as agreement. This is known as tacit acquiescence. In other words, you've accepted their classification by failing to object to it. That's why our position at Freedom Law Group is clear and simple. Always respond to IRS correspondence, unless it's just a receipt letter confirming they received your prior correspondence. Do not ignore letters that assert claims or deadlines. And always challenge any false assumptions, like, for example, being labeled a taxpayer when you've lawfully revoked that election. In the remainder of this video, we'll walk through some of the most common letters you may receive from the IRS after your revocation of election has been sent, and explain what they mean and how to respond. Let's dive in. One of the more common letters you may receive is a basic acknowledgement letter. This letter typically states that the IRS has received your documents and asks that you allow up to 6 weeks for a review and response. It serves as a simple confirmation that your revocation of election has been received and logged into their system. While the language may seem vague or noncommittal, this letter is routine and requires no action on your part. Still, it's important because it serves as an official acknowledgement. We recommend retaining this letter with your other ROE-related documents. Note that not all clients receive this letter. Don't worry if you don't. What matters most is that you retain proof of delivery, such as a return receipt or a USPS tracking screenshot. A sample PDF of this letter is available in your resource center. Another letter our clients sometimes receive is IRS Letter 96C. This letter is sent directly in response to the revocation of election and generally begins by acknowledging receipt of your correspondence. It then typically states that no action is necessary on your account. While not every client receives this letter, it's incredibly valuable. It's an implicit admission that your affidavit was reviewed and that no further action is needed. Although increasingly rare, we have clients who are still receiving this letter, including one as recently as this month. A sample copy is also available in the Resource Center. Roughly 6 to 12 months after submitting your revocation of election, you may receive a CP-59 notice. This is a computer-generated letter sent automatically to individuals who, according to the IRS system, failed to file a tax return. Since you will no longer be filing tax returns going forward, it's expected that this notice may eventually appear. That said, not all of our clients receive one, yet another example of the inconsistency within the IRS. If you do receive a CP-59, we recommend that you respond. Some in the broader freedom movement suggest ignoring such letters, believing the IRS no longer has jurisdiction. And in full transparency, that was once our position as well. However, our team at Freedom Law Group is constantly learning and refining our guidance, and we now encourage clients to reply to the CP-59. The response process is simple. In the Clients-Only Resource Center, download and print IRS Form 15103, which we have specifically modified for our clients. Don't use the standard version available on the IRS website. Complete only the highlighted sections: your name, social security number, tax year in question, and your signature. The IRS asks for a reason you didn't file, and we've pre-filled 2 key statements for you. 1. You've terminated your election to be treated as a statutory taxpayer. 2. You're not a statutory U.S. citizen or permanent resident of the statutory United States. For context, in the tax code, United States for income tax purposes refers only to the District of Columbia per 26 U.S.C. 7701, A, 9, and 10. There's also a line allowing for additional explanation, which refers to page 2. On page 2, we provide the following legal justification. Not required to file per the termination of election. I have never been a U.S. citizen or permanent resident. A U.S. citizen per 8 U.S.C. 1401, A, in Volume 3C of American Jurisprudence, 2nd edition, Section 2689, quote, who is born in the United States and subject to United States jurisdiction, close quote, refers only to those born in the District of Columbia or U.S. territories per IRC Section 7408, d. The IRS must know and properly follow its own statutes designed for its territorial jurisdiction. The U.S. Congress has granted my option to permanently exit the federal income tax system, as provided in IRC Section 6013, G, 4A, and made permanent under Section 6013, G, 6. The IRS is bound by this statute and has no authority to disregard it. Attached is a copy of my revocation of election, delivered to the IRS Commissioner in Washington, D.C. The IRS cannot compel Americans to associate with the national government in violation of the 13th Amendment. This issue is resolved by law, as enacted by the United States Congress in the Internal Revenue Code. Once complete, sign, date, and mail it using the instructions provided in your Resource Center. That's it. This notice formally and legally rebuts the IRS's assumptions that you're a taxpayer and failed to file. As a side note, if you've already completed the ROE process through another company or provider but are not receiving the support or education you need, contact us to inquire about special pricing for access to our Resource Center. It includes 14 video training modules and all of our client materials, with more video modules being added all the time. Another letter you might receive is IRS Letter 3176C, which about 5 to 10% of our clients have reported receiving after completing their revocation of election. This letter accuses you of making a frivolous argument and threatens a $5,000 penalty under IRC 6702. But let's be absolutely clear, this letter is nothing more than an intimidation tactic, one rooted in fear, not law. The IRS sends this to discourage you from exercising your lawful rights. And here's the tell, in all 5 pages of Letter 3176C, and even in the IRS's lengthy publication titled The Truth About Frivolous Tax Arguments, they never once mention the revocation of election. Not a single time. That's not an accident, it's because they can't. The revocation of election is statutory. It's rooted in 26 U.S.C. Section 6013, G, 4A, and G, 6, enacted by Congress itself. It is not a theory. It is not a protest. It's not an argument. And it's not optional for the IRS to ignore, and they know it. So instead, without mentioning the revocation of election, without mentioning the laws that you cited, they just lump your quote, correspondence, close quote, in with a long list of frivolous tax arguments in an effort to create confusion and fear. We've dedicated an entire video in the Freedom Law Group Law Library to Letter 3176C. It's called The Revocation of Election and Frivolous Tax Arguments. We encourage you to watch it as soon as possible. But what's important to note is that if our current or even future clients receive IRS Letter 3176C, or similar, don't stress. We've already written a 13-page response letter that absolutely dismantles the IRS letter. It's available in your Client Resource Center, and the letter is brilliant. It's brutal, factual, and legally devastating. We go so far as to name the man who signed his name at the bottom of the letter, and we put him on notice, personally, that our client may pursue him for multiple felony charges should he pursue this matter, and we cite the federal laws he will be breaking by continuing to pursue our client after a revocation of election has been properly executed. And as expected, not a single one of our clients has received a follow-up letter from the IRS after sending our 13-page response letter. The IRS goes silent. That's the power of knowledge, and of having the law on your side. Now, let's move on to a few of the more serious letters you may receive for tax years prior to your ROE. If you fail to file a tax return for any pre-ROE year and the IRS attempts enforcement, you may receive a Notice of Deficiency such as Letter 3219, 3219N, 950DO, or 1862. You may also receive a Notice of Federal Tax Lien such as Form 668Y, or Letter 1058, or a Notice of Intent to Levy, such as Letter LT11. These letters are serious, but don't panic. In many cases, you may qualify to challenge these actions in U.S. tax court by filing for dismissal based on lack of jurisdiction, without needing to hire an attorney or appear in person. If you act quickly and follow the proper steps, the tax court may dismiss the case entirely and cancel the associated tax debt. In fact, we offer a full money-back guarantee on this service if we are unable to get your case dismissed. But again, this is only for those who have unpaid taxes prior to sending your ROE. Okay, that wraps up this video. Congratulations on taking your education seriously and continuing to claim your freedom. We're honored to be on this journey with you. Take care, and we'll see you in the next video.